In the definition section of the Act, it explains who is a complainant, and the complainant is the person or individual who goes to the court to apply for a protection order. So, if you have been violated, abused, of one form or another, you could go to the court and make the application, and you will be deemed the complainant. The definition section of the Act also explains what is a protection order. And a protection order is that order that is made by the court once the court is satisfied that the conduct is capable of constituting a criminal offense against the spouse or the person who has been violated. So once the court is satisfied with the evidence before it, it would issue or award a protection order. The definition section also explains what is harassment. And for our purposes, the harassment would include things like persistent verbal abuse, threats of physical violence, malicious damage of the property of a person, and any other means, as well as if the person is following you from place to place, or if the person is hiding your clothes or your property, or denying you the use of your clothes or your property, or if the person is watching or besetting you or stalking you, all that would be deemed by the law as harassment. Section 3 of the Act also speaks about what is a protection order, and I mentioned that, but I should say, for your purposes, even though the action of the perpetrator, once you're violated, you come before the court, it comes into the criminal court. It seems as if the court uses not the criminal standard in terms of the proof, but they look at the civil standard, and that is a question that we are concerned about. So I think that while all of us here have concerns, at some point you might be able to make a petition, and at this point I would like to say that I heard on the news recently that the Domestic Violence Protection Order Act is to be amended. So if all of us here have concerns, I think we should write to the appropriate ministry and lay our concerns to them, or if there's provision for any town hall meetings, we should go to those meetings and make our points known and heard. Who could apply for a protection order? The spouse or a former spouse of the person who was violated. So if you were the former spouse of the present complainant, you could go and apply for the protection order for that person. Or, let me put it in simpler terms. If I am the complainant, I've been abused, and you're my former spouse, former spouse, you could go to the court and make the application for the protection order. Or a member of my household could go to the court and make an application on my behalf for the protection order. I mean, the police have been battered here this evening, but the law makes provision for the commissioner of police or persons under the authority of the commissioner of police, which is the police officer, to make the application on my behalf if I was abused, or on your behalf if you were abused. And an agent could also make the application for the protection order, as well as an officer of the child care board or the welfare department. So any of those lists of persons or those categories of persons could go on your behalf and make the application for the protection order. Section 7 of the Act makes provision for things that the court will take into account. And the protection order under that section may make provision for the perpetrator or the person who is violating or abusing you to be restrained. That restraint could be from the premises or the house where you live, restraining him or her from going to your workplace, or if you're at school, from going to that place, or if there's some specified location that he or she might be able to see you, and he would also be restrained from that locale. He could also be restrained from approaching you within a certain distance, or he or she could also be restrained from staying on the same premises if he or she is under the influence of drugs or that person is intoxicated. So the law would, or the court would make, the law I should say, would make provisions for a restraining order to be sort of aside from or part of the protection order. There's also another section that I also need you to be aware of, and this deals with matters that the court will take into account. When the court is determining whether or not to make the protection order, the court would consider a number of things. The court would take into consideration that the person is protected from violence and harassment. It would take into consideration the welfare of a child or children who are members of the household of the perpetrator or the complainant. It would also take into consideration, and this one I think is a bit difficult for us as well, but the court would also take into consideration the preservation and protection of marriage, whether it's a common law marriage or a legal marriage. It would also take into consideration the protection and assistance to the family. But I think in this instance, because this seems difficult for us to swallow, what the court will also do is, if the court or if a party appears before the court who is so physically battered and abused, I don't think that this particular section, it will give all the consideration to. They will look at the physical affliction that the person has encountered, rather than just going by this particular section of the act. The court also takes into consideration the accommodation needs of the household. It will look at whether or not they having issued a protection order, it may be hardship to the perpetrator or any other person as a result of making the order. And it would take into consideration as well any other matter in the circumstances of the case that is relevant. Another thing that you will be interested in as far as the law is concerned is that before making before granting a protection order, the court will also take into account the issue of the property, the income, the financial resources, and the financial obligations of both the complainant or the victim of the abuse and the respondent or the perpetrator who did the abuse. The last thing that I would want to share with you is what would happen if the protection order is breached. Where the respondent, and the respondent is the term the court would use, but we are talking about the person who commits the abuse, who is the perpetrator. So where the perpetrator breaches or contravenes the protection order, he or she, because it could be a man or it could be a woman, he or she is guilty of an offense and is liable on conviction to a fine of $5,000 or 12 months in prison, or both could apply. So as far as I am aware and as far as we are concerned, even though we might think that a protection order is just a piece of paper, it is a start, and there are provisions in the law for us to make the application, and the court will take the necessary course of action.
Good afternoon again, ladies. We all took the time to at least try to relay our own feelings around domestic abuse, intimate partner violence, and the like. And now we would love to hear from you, your thoughts. Is there any issue, for example, around a particular area of intimate partner violence that you would like to discuss? For example, I would have raised the point around what our role is and who's to blame when these things happen. At what point do we intervene?